Mr. Kutsia, can I just confirm we are core 8 from what I can see?
That's correct, Chair. We may proceed. I did send him the link. I actually saw him early on in the meeting, then he disappeared. But
there we go. There he is.
Okay.
Morning, Member Van Wyk.
Morning,
Right.
morning, morning, Chair.
Thank you very much. Right, colleagues, it's 1 minute past 9, and we are going to start the meeting. Today on the agenda for our Standing Committee meeting on Local Government, Environmental Affairs and Development Planning, we have feedback on the comments received from the George and the Mossel Bay municipalities and the Western Cape Monitoring and Supported Municipalities Amendment Bill, as per our meeting last week, where it was raised by members of SALGA, and thank you again to those members. We will have some feedback on that. Following on from that, we will then consider as item 2 the Western Cape Monitoring and Supported Municipalities Amendment Bill, after which we will then move on to resolutions. I'd like to welcome everybody to the meeting. In particular, sorry, someone's, Mr. Kutsia, I think it might just be, there we go. In particular, Member Dirk Wessels, who is joining us for his first meeting as an official member of the committee after Member Peter Johnson has moved off the committee. And with that, I am going to allow for a round of introductions for members joining us today, starting with myself, Dave Bryant. I'm the chairperson of the Standing Committee, and Member Wessels, if you would like to go first.
G'day, Chairperson, Dave Wessels, and I'm a member of the committee. Thanks.
Noko Masipa, I am a member of this committee. Good morning, colleagues. Good morning, members of the WCPP. Thank you.
Good morning, Chair. Good morning, colleagues. Good morning, members from local government. I'm Leon van Wyk. I'm now a member of this committee. Thank you.
Good morning, Chair. Good morning, colleagues. My name is Noel Constable, and I am a member of this committee. Thank you.
Good morning, Chairperson. Grant Marie. I'm a member of this committee.
Good morning, Chairperson. My name is Beauty Stoffels, and I'm a member of this committee.
Sure. I don't think we could look for a better start. That was probably the most seamless transition between introductions we've had in the history of the Parliament. Well done, everybody. We also have Councillor Anthony Moses joining us from SALGA. Mr. Moses, sorry, Councillor Moses, very welcome to you. Is there anybody else from SALGA joining you today?
Yes, Chair, it's Mr. Layusa Ndamela that's also joining us, Chair. Thank you, Chair.
Fantastic, no problem. All right, so colleagues, this is a virtual meeting. You would be aware of the rules for virtual meetings, but just as a quick refresher, obviously only members of the committee are entitled to pose questions and participate in the meeting, along with officials and guests who are given that opportunity by the chairperson. And if you do want to raise an issue, raise your hand as per the functionality within the Teams system. Also, please ensure that your camera and your microphone are off when you are not participating in the meeting. I'm then going to go on to apologies. We have apologies so far from Minister Anton Bredell, Mr. Paulser, the HOD, and then joining us today from the Department of Local Government, we have Mr. K. Makan, Advocate Birch, Ms. Williamson, Ms. Van Sale, and then from the Department of the Premier, Ms. Tor. We have spoken around the SALGA representatives, and then Mr. Marsdorp, our legal advisor from the Western Cape Provincial Parliament. Have I missed anybody, or is there any apology for any of those names mentioned?
No, Chairperson, that's all that's present here.
Okay, fantastic. Thank you very much to everyone for that. Okay, we are then going to move on to the feedback on the comments received from the George and Mossel Bay municipalities. As mentioned, this was originally going to be included on that matrix, but for some reason it just slipped off. But it has been received, and there are responses which have all been distributed to members in due time. And if I can then hand over perhaps to Mr. Birch, who would be able to just take us through those inputs and responses. And I do think, if possible, we could flight those as well, just so that members have sight of that while we're discussing it. I don't think it's going to be a very long discussion. I think the comments have been well responded to, but Mr. Birch, over to you.
Thank you, Chairperson, and thank you, members. Just flight. I can see it's being flighted already. Okay, thank you. Then if I proceed, to start with the comments from Mossel Bay. Chairperson, would you like me to read through all of the comments, or just primarily focus on the department's response to the comment?
Yes, I think if you can just highlight some of the key comments that came through, and yes, refer to your responses. I don't think we have to read out everything verbatim.
Thank you for that guidance. Yeah, in essence, Mossel Bay largely supports the proposed amendments. There were some concerns relating to the proactive monitoring, which also was largely welcomed. The comment here, it was submitted that the proactive monitoring must be justifiable in the circumstances. And there was also a question on the cost implications. And the department's response is essentially that the report that is developed from any proactive monitoring must be provided to the municipality. And as we mentioned during our previous engagement with the committee, the intention here is to assist the municipality and enable it to take note of any identified risks that are identified, any of the suggested improvements that are proposed to procedures or processes, and that's to prevent fraud, corruption, maladministration, and malpractice. Then the provincial minister must also in writing determine the scope of the monitoring and support to be provided. and the other terms of reference for the designation. It is thus not an open-ended proactive assessment, and it will also not have any cost implications for the municipality in relation to people that are sent to the municipality to conduct that proactive assessment. And then in relation to, there was a concern about potential reputational risk as well involved for the municipality. They just noted that those reports can, if appropriate, can also be considered by the municipal council in a closed session, should that be necessary. Then if I move on to the next comment from George Municipality. So yeah, George Municipality raised some questions relating to section 155(6) of the Constitution, and they take cognizance of the intention of the provincial legislature and the proposed bill. But the indication is that it serves more as a tool to facilitate investigations rather than supporting and capacity building. And there is also a comment that it provides a provincial minister with powers that he doesn't possess in terms of national legislation.
Sorry, Mr. Birch, just very quickly, if you can just go back to that item 2 in terms of the response to the George Municipal Manager. It was raised with me earlier that perhaps that section, the provision to be read with sections 1541 and 1567 is slightly incorrect. There's actually a different section that is needing to be referred to there. I'm not sure, maybe Mr. Marsdorp, if you were able to just provide us a bit more context.
Yeah, Chair, in my perusal of the comment of the department, the extent of the response is absolutely correct, as Mr. Birch has indicated in response to George. I just noticed that the reference, Mr. Birch, to section 156 sub 7 of the Constitution is incorrect. I think, having regard to the purport of the response, that may in fact be section 155 sub 7, because that 155 sub 7 speaks more directly to the textually to what you may have responded. So I think that's just it could be a typo. It's just 1557 as opposed to 1567, Chair.
Yeah, that's perfect. Thanks. Just that amendment. Are you happy with that, Mr. Birch?
Yes, thank you, and thank you, Mr. Marsdorp. Yeah, correct. I think that's meant to be 1557. It does look like that should be.
Great. Sorry, let's continue. I just thought to get that out the way now while we're going through it, but carry on.
Thanks, Chairperson. So the general constitutional duty on provinces to monitor municipalities is located primarily in section 155(6)(a) of the Constitution. That must be read with 154(1) and then 155(7). And then those provisions establish the provincial duty to provide for the monitoring and support of local government. Yeah, essentially, investigations are an essential component of the provincial minister's duty to provide for monitoring and support. We saw that given effect to by the Western Cape High Court in the City of Cape Town matter, where the court indicated that and confirmed that the power of the MEC under 106 of the Systems Act to investigate fraud, maladministration, fraud, corruption, and other serious malpractice falls within the monitoring powers of provinces. Section 106 of the Systems Act, furthermore, essentially contemplates that these investigations be in terms of applicable provincial legislation, which in this case is the act that is sought to be amended through this process, Chairperson and members. Then the proposed amendments align with the principles laid down by the courts and are legally sound, and appropriate amendments to the Act by providing for mechanisms to better enable the application of 106 and to fulfill the direct constitutional duty provinces bear to monitor municipalities. In the absence of the power to secure relevant records, the provincial minister may, in many instances, be unable to fulfill his or her duty to effectively investigate suspected maladministration, fraud, corruption, or other serious malpractice, with the knock-on effect that the provincial executive may be unable to perform its constitutional function where appropriate of intervening in a municipality, as contemplated in Section 139 of the Constitution. And then the various powers afforded to the provincial minister in terms of the Act, as proposed to be amended by the Amendment Bill, it's submitted fall within the ambit of its constitutional obligations, and the Municipal Council is also then responsible for its obligations and responsibilities. The provisions of the Amendment Bill relating to investigations under 106 of the Systems Act are detailed insofar as it is considered that the inclusion detailed insofar as it was considered that the inclusion of detailed safeguards is necessary. However, there are also clauses in the Amendment Bill that seek to reduce the need for investigations. An example of that is the proposed insertion of Section 4, capital B, which relates to preliminary assessments. And the purpose of that provision is to prevent unnecessary investigations by the provincial minister. So we're trying to seek a balance here, essentially what the comment is getting at. Excuse me. Then some specific comments that were addressed as well. The various powers afforded to the provincial minister in terms of the Act, as proposed to be amended by the Amendment Bill, fall within the ambit of its constitutional obligations. The proposed Section 2A provides for the principle that municipalities must provide access to the relevant records on request of the stated functionaries, and underlies the more specific provisions in the Amendment Bill. Then there was a concern relating to Section 3A, and whether or not it can only be triggered on a request specifically by the municipality. So as opposed to 2A that I just mentioned, 3A specifically here, the proposed Section 3A relates to the proactive monitoring. No trigger event is provided for. The provision flows from the constitutionally imposed obligation of provinces to provide for the monitoring and support of local government. And the proposed 3A does not impede a municipality's autonomy, but is rather a mechanism which will better enable the provincial government to support municipalities and promote the development of local government capacity to enable municipalities to perform their functions and manage their affairs. Section 3, capital A, enables the provincial minister to designate a provincial support officer who can, amongst other things, assess the implementation by the municipality of applicable municipal policies, municipal standard operating procedures and practice notes issued by the provincial minister. And the report developed will then be provided to the municipal council and will assist the latter to perform its functions. A proposed section will enable the provincial support officer to identify risks and accordingly make the municipal council aware of these risks, and then suggest improvements that the municipal council can make. Then there was a comment in relation to Section 4, capital A, and the written notice. So the written notice that is referred to specifically in section 106(1)(a) of the Systems Act, just to highlight here, that can only be issued if the provincial minister has reason to believe that the municipality cannot or does not fulfill a statutory obligation binding on that municipality, or that maladministration, fraud, corruption, or any other serious malpractice has occurred or is occurring in the municipality. So that notice can only be issued under those circumstances. And the provision for a notice to municipalities in the proposed section 4(a), that would apply in circumstances when there's information of a suspected failure by a municipality to fulfill a statutory obligation, or that there's fraud, maladministration, corruption, other serious malpractice has been received, and the provincial minister has reason to believe that a record relating to the information received will be concealed or destroyed if it's not secured as a matter of priority. Then this enables the provincial minister to designate a provincial support officer to travel to the municipality to inspect, secure, and copy a record relating to the received information. Factors to be considered by the provincial minister in determining whether the inspection and securing and copying of a record is required have been included in the bill itself. And the proposed section 4(a) on the inspection, securing, copying of records, where the threshold criteria are met, therefore supports as well as supplements section 106 of the Systems Act, by ensuring that the provincial minister will be in a position to fulfill his or her obligation to issue a written notice in terms of section 106(1)(a), or to investigate suspected maladministration, fraud, corruption, or serious malpractice in municipalities. And that's as provided for in that section. Section 106 of the Systems Act furthermore expressly asserts that these investigations be in terms of applicable provincial legislation, which in this case is the act that is being amended. Then with regards to the proposed amendment of section 5, and in particular the proposed deletion of the requirement to inform the municipality and invite comments, the provincial minister will remain bound by the principle of procedural rationality laid down by the courts. And this principle holds that the requirement that the exercise of a public power must be rational in order to be valid extends beyond the merits of official decisions to the means chosen to take the decision. Namely, the procedure followed for the purposes of taking a decision must also be rationally related to the objective sought to be achieved. Hence, the provincial minister will be bound to act rationally with regard to the process undertaken in section 106 investigations. It is not necessary for this to be stated specifically in legislation, and the circumstances in each and every case will need to be analysed to determine the appropriate procedure to be followed. This similarly applies to the proposed amendments to section 6 as well. And then there was just one more comment in relation to section 7(a). That's related to the entry and inspection without a warrant provision. So the proposed 7(a)(8) that provides for the entry and inspection powers that may be exercised without a warrant, without a warrant, with the consent of the highest ranked staff member or political office bearer at the property or premises concerned, or where there are reasonable grounds to believe that the warrant would be issued, but the delay that may be caused by applying for the warrant would defeat the object of obtaining the warrant. This provision is necessary and justifiable to ensure that in the exceptional circumstances stated, the objects of the amendment bill, once in operation, will not be defeated. Just to mention as well, it's a fairly common provision with similar investigation powers. That provision relating to obtaining a warrant, obtaining that documentation without a warrant in exceptional circumstances. Thanks, Chair. That's in essence briefly the responses from the department to the comments from the two municipalities. I'll leave it there.
That's great. Thank you very much, Advocate Birch. Appreciate it. And I think you've gone into all the detail that's required. I think we've got a comprehensive understanding both of the inputs and the responses, which I think are very well founded. And I have also been advised by our legal advisor that there are no issues with the constitutionality of any of the responses in terms of the issues that have been raised. What I am going to do, though, is if members have any questions of clarity from Mr. Birch in terms of the issues raised or the responses, please raise your hand. I am also going to allow Councillor Moses from Selga, if he wishes to, as this was one of the issues that was raised during the first presentation. Also, colleagues, I would like to apologize for an early morning mistake. I said the name of Member Wessels instead of the name of Member van Wyk. I'm not entirely sure why, but Member van Wyk, you are most welcome as a new member of the committee, not Member Wessels, who I know very well and has been on many trips with us before. But Member van Wyk, you are most welcome as our newest member. If that can also be minuted, thanks very much. Colleagues, if anybody has any questions, I don't see any hands being raised. So I think, we do have Councillor Moses. Councillor Moses, over to you.
Chair, thank you so much. Just a question of clarification in the last point that was made, the issue that you need to gain access even without a warrant. I just wanted to check, is that based on the theoretical side of the law, or is it based on case law where certain cases in these instances took place? Because I'm just checking the legal implications that it might pose if you get entry to a property without a proper warrant.
Mr. Birch?
Yeah, thank you. In terms of the entry to property without a warrant, the purpose of such is merely to, and for the purposes of the powers being exercised. Here, the powers are essentially for another government and a designated official who is ultimately going to collect evidence and copy documentation. So it's not just to take the documentation away. A criminal investigation is also not being conducted in relation to the powers being exercised in relation to the person that would be getting access to the property here. The powers can also only be exercised in accordance with the provisions that are specified in the Act. There are safeguards that are provided for there as well. And should anyone exceed their powers as they're authorized to do, that would be able to be challenged through the courts. Thank you.
Thank you very much, Advocate Birch. Councillor Moses has said maybe the word warrant should be replaced. We'll take a response in a second. We also have Member Constable with the question of clarity on the Mossel Bay and George inputs.
Yeah, thank you very much. Again, I agree with the municipal manager of George municipality. There is too much power given to the provincial MEC with regards to entering and doing what he's supposed to do. And rightly said by the or by George municipality that it really impedes on the municipality's autonomy. It will create a lot of problem. And I listen what Advocate Birch is saying, and we can contest that with regards to municipalities then go to court. But all of us knows that municipalities have limited resources. This government that we are sitting on, the provincial government, we are making provision specifically for investigations to municipalities, meaning that we budget to go and investigate municipalities. That means if a municipality have a problem with us investigating them or coming to our entry, we already have the resources to go to court, while municipalities don't have that such resources. And that brings me back to my question and my comment last week that says there is no protection for municipalities in this bill. Hence, I'm agreeing to with George municipality. There's too much power, and we will have problems going forward with implementing such a bill that creates a vacuum and creates a problem where provinces do have too much power, and really in contradiction with what the national legislature and national constitution have. The legal guys is saying that there's no infringement. We are saying that there are infringement, and we note that infringement. We saw that infringement. We can use a lot of nice big words. The practicality of what's happening on the ground, that is where the problem is. And maybe Mr. Marsdorp and Mr. Advocate Marsdorp and Burgess, they must go and see for themselves what is happening specifically on the ground, and specifically where municipalities, where the ruling party is not in charge. Thank you, Chair.
Thank you very much, Member Constable, for those inputs. Mr. Burge, I don't know. I mean, it's up to you how to respond. There weren't specific questions of clarity. We have the one from Councillor Moses so far, but thank you for those inputs, Member Constable. And we will obviously have an opportunity in the next item to say whether or not we are in support of all of those specific sections. We have Member Stoffel, and then we will hand over to Advocate Birch and Ms. Tor for responses. I see Ms. Tor's got her hand up, so we'll take that as well. We'll take Member Stoffel, and then I see Member Masipa has just popped his hand up as well. So Member Stoffel first, then Member Masipa, and then we'll take the answers.
Good morning, Chairperson, and good morning, everyone. Am I audible, Chair?
Yes, you are, ma'am.
Thank you very much, Chairperson. Chairperson, first of all, let me appreciate the presentation from our legal department, and then also I just want to verify, Councillor Anthony Moses is representing again SALGA, if I'm correct.
Yes, SALGA, South African Local Government Association. Yes.
Oh. And then Mr. Romeo Masdorp is representing.
He is the Western Cape Provincial Parliament's legal advisor.
And the NCOP, sorry, Chair, I just want to be clear.
Yes, no problem.
And the NCOP has been representing by whom here?
We don't have an NCOP representative on the committee now.
We didn't invite them.
I don't think there is a mandate to have them invited, from what I understand. Mr. Kutsia, was the NCOP or a representative invited? Or they've got their own processes, from what I understand.
Chairperson, that's correct. This is a Western Cape legislation, so we are not obliged to invite them. Our meetings are open, and if they wanted to attend, they were welcome to attend. But either the practice is that we don't invite them.
Yes, and Salga is Salga Western Cape. Yeah,
that's
Sorry,
correct. Yes,
that's it. Yeah. Member Stoffel, back to you.
Thank you, Chair. The reason why I'm asking, Chair, obvious, Chair, this the input won't be objective. We know it all. It will be in a kind of a biasness. And I find it very difficult, Chair, even to proceed in sitting in such a committee meeting, because all the representative is from the Western Cape. We won't have a constructive and objective debate in terms of this bill. I want this to be recorded from the African National Congress. And then secondly,
sorry, Member Stoffel, I don't want to interrupt you, but this is the Western Cape Provincial Parliament, so that, you know,
I know,
this is
I just wanted to be
representation from the
recorded.
Western Cape.
I just wanted to be recorded,
Okay,
Chair.
no, we will record that.
Yes, please record that, because at some stage you will need this comment. And then secondly, I fully agree with the comments of George. I fully agree. 1541, 1556, the municipalities must be given a chance to manage their own affairs. I fully agree. I also agree with them whereby they say this bill is more to facilitate investigations rather than supporting or capacity building. So I will stop there, waiting for the other engagement. But even the response from the department to that comments from George, it's not inaccurate what the people is actually saying. So it doesn't really answer, it doesn't justify what those people are trying to say. So, Chair, I will pause there. Thank you very much.
Thank you again for those inputs, Member Stoffel. Member Masipa. Member Nokomasipa, are you there?
So, yeah, okay. Chair, sorry, man. I was battling with the mic to unmute myself. Thank you very much, Chair. Chair, I think my question really relate to the constitutionality, because before me is the South African Republic Constitution, which obviously was cited, and I see section 155(6) and 7 kind of is very clear about what we are doing in terms of monitoring and support of local government in the province, which the legislation obviously provides that the provincial government needs to provide that. So, Chair, I acknowledge the fears and the worries that other colleagues are obviously having in this regard. But I do think that there is a constitutional, support in terms of what the minister is trying to do. But the question may be to the legal advisor, Mr. Master, is what are those wordings that might constitutionally, require some tweaking or amendments that you will recommend, just to give assurance that this is not a witch hunt tool? Because I think the colleagues, what they are seeing or deeming this legislation to be is a witch hunt tool. But if you look at it, it's from my perspective, from a constitutional point of view, is spot on. It's in line with our Chapter 5 of the Constitution of the Western Cape Provincial Parliament, and also in line with the national constitution. I think that might, you might just be able to assist us and support us in going forward. Thank you, Chair.
Thanks very much, Member Masipa. And as mentioned earlier as well, we will have an opportunity in the next agenda item to say whether or not we support. So we are taking more questions of clarity on the George and Muscle Bay inputs, and you have raised one there. So I see your hand, Member Constable. I'm going to take you after this round of answers, because you might have your question answered in this session, and then but we'll see. I'm going to hand over to Advocate Birch and Ms. Tor for responses, and then if need be, we'll do another round of questions. Thank you.
Yeah, thank you, Chairperson and members. I'll let Amanda Tor go first, and then I'll go afterwards. Thanks.
Thank you, Chairperson. Just to respond to the question put regarding the constitutionality of the provisions in the bill, and also the comment made regarding inspections without a warrant. Those provisions, firstly, they've been drafted both with due regard to what the case law says regarding the monitoring powers. So they reveal a concern for the autonomy and integrity of local government, and prescribe a hands-off approach between local government and the other levels of government. But on the other hand, acknowledge the requirement that higher levels of government monitor local government functioning and intervene where such functioning is deficient. So that's what the bill is trying to seek, the balance as laid down in the case law. Also, just to say, it's also been analysed through the prism of the limitations analysis in the Bill of Rights. These provisions are novel. There are not any provisions that directly mirror these provisions in law. So I cannot point to a particular case where an exact provision has been found to be constitutional, because, as I said, is novel. It's in a very unique context, in the context of monitoring. But out of an abundance of caution, we've analysed the provisions through the limitations analysis in the Bill of Rights. That said, there is no authority that this constitutes any kind of a limitation, but it's deemed appropriate to apply those principles. And when it comes to the provisions in proposed section 4A, entry onto premises without notice, a very, very high threshold is set in order for those provisions to be invoked, as you will see in the bill. There must be a reasonable suspicion that the records will be concealed or destroyed if they're not secured. And there's detailed criteria also set out as to when the minister may invoke those provisions. That must still be under the authority of a warrant, and the restrictions as to time and place and manner of search still apply to those provisions. The most exceptional circumstance without entry without a warrant, that's going to be in those very, very limited circumstances. And one of the principles that the courts apply when determining if there's been any rights infringement and whether the infringement is justifiable is, are there any less restrictive means available? So we've very carefully looked at less restrictive means in the bill and built those in, and a warrant is one. But if obtaining a warrant is going to defeat the purpose of the provision, then there's no other less restrictive means available, essentially. So that's why the threshold criteria have been set so high. There's essentially the minister would have exhausted all options, and this is the only way he or she could fulfill the monitoring power, and it's considered to be justifiable in those circumstances from a legal point of view. So in principle, I believe it is constitutional for those reasons and does strike the appropriate balance. Thank you, Chair.
Thank you, Ms. Tor. I think that makes a lot of sense. Mr. Birch, Advocate Birch.
Yeah, thank you. I think maybe just to mention as well, and I think the committee would have seen from our previous set of comments and engagements that we've in fact shared copy of the proposed bill with the other provinces as well as National Kochte. We've had engagements with the other provinces as well as National Kochte in relation to the proposed bill and the act in terms of how it's proposed to be amended. And we've actually tried to share that resource with the other provinces in order to capacitate some of the other provinces and see whether or not they would actually want to adopt similar legislation in their provinces. Yeah, thank you.
Thank you very much, Mr. Birch and Ms. Tor. Colleagues, are there any other questions of clarity around the Mossel Bay and the George inputs? Member Constable, and then Member Murray.
Thank you, Chair. Chair, no question with regards to the comments, but just a question of concern. Why is the MEC and the HOD not part of this meeting? This is the second meeting, I believe, we discussed this very crucial amendment bill, and there's their absence is very disturbing for me. Thank you, Chair.
Thanks, Member Constable. Member Murray.
Thank you, Mr. Chair. Thank you. I'm sorry for the delay, Mr. Chair. Mr. Chair, I just wanted to, in terms of Mossel Bay, the response to Mossel Bay. Now, they were concerned about the reputational damage or the potential reputational damage. Just going to encounter to which the department answered. It said that in relation to a potential reputational risk for the involved municipality, the risks or the reports issued can, if appropriate, be considered by the municipal council in a closed session. Now, I think I've raised it in the previous meeting that the minister does have a discretion. And sometimes the news, is already in the public domain that a particular municipality is going to be investigated. That can potentially cause not just reputational damage to the municipality, but also, I guess, there could be some political room for political maneuvering. Does the department think that we have sufficient safeguards to protect the municipality from frivolous, allegations in terms of this particular amendment, and then also just in terms of the reputational risk? Is that the best we can offer in terms of assuring the municipalities that they will not be unnecessarily, have this cloud hanging over them because of some other reasons? This particular bill is called the Support and Monitoring, Monitoring and Support of Municipalities. This opens the door perhaps too widely for the exact opposite, in terms of rather focusing not on monitoring and support, but bringing allegations or investigations for supposed corruption that's happened, not being confirmed yet. I hope that is clear for a response.
Thanks very much, Member Murray. Yeah, I think that's clear. Member Constable, just in response to your question, so the minister and the HOD were invited to the meeting, but unfortunately their diaries were already booked and they weren't able to attend. But all of this information, I think, is made accessible to them afterwards. you obviously are more than welcome to raise those issues directly with the Minister's office if you feel there's something that you would like to raise directly. They're not official members of the committee, but they are certainly invited and attend where possible. Advocate Birch, in terms of Member Marais' questions.
Yeah, thank you, Member Murray. In relation to the safeguards to protect a municipality from frivolous allegations, municipalities always have they've got their own obligations and responsibilities to investigate allegations themselves. That's over and above when the minister has a duty and obligation to also investigate. Then the bill is proposing to allow for the MEC to also allow for, when he receives certain allegations, to have that referred to the municipality for the municipality to conduct its own preliminary assessment of those allegations, and then to report back to the minister on their findings. In essence, yeah, we believe that there are sufficient safeguards here to stop these sort of frivolous allegations that are received, and we've tried to put in place measures so we can actually reduce the number of investigations that would have to be conducted by the provincial minister when it's not needed, essentially. In relation to the reputational risk issue that was raised by the municipality, that was specifically in relation to the proactive monitoring section, being 3A. And that's where that concern was raised. And I mean, if we look at what that section is trying to do, it allows for a provincial support officer to be designated, and that support officer goes into the municipality and assesses the municipality's compliance with its own policies. It looks at whether or not the municipality is complying with its own policies, procedures, whether or not it's complying with the practice notes. That person will then try and identify any risks and suggest improvements to the municipality. So, from a reputational risk perspective, the nature of the powers there, I would submit are not the type of powers that are going to lead to that much in the way of a reputational risk to the municipality. The report that's developed is a report that just highlights where there are deficiencies in their own processes, where the municipality and the municipal administration is not following the policies and procedures that have been adopted by the council. It's suggesting improvements on where council could take corrective action in relation to that and try and resolve some of those issues that have been identified. Yeah, thank you.
Thanks, Advocate Birch. Member Stoffels, a question of clarity on the Mossel Bay and George inputs.
Chair, mine is only on the investigations that you've indicated. Die ligsinnige allegasies. Ek wil weet, sê nou die munisipaliteit doen sy eie ondersoek en dan die provinsie doen ook sy ondersoek in daai allegasies, daai ligsinnige allegasies. En dit kom dat daar verskillende uitkomste is, verskillende rekomendasies is. Wat in daai geval? Want daar was 'n interne ondersoek en daar is nog 'n provinsiale ondersoek. En aan die einde van die dag as verskillende uitkomste van die investigation of recommendations. Wat doen ons dan in daai geval? Dankie, voorsitter.
Thank you very much. Baie dankie, Member Stoffels. Advocate Birch.
I mean, there have been instances where municipalities have investigated certain of the allegations that have been received by the provincial minister, they've concluded that there've been no issues in relation to and sort of disputed the allegations. A number of the 106 investigations that have been conducted have had similar circumstances where the municipality themselves have said that there's no wrongdoing that's occurred. And a number of those 106 investigations that then ultimately get concluded find significant wrongdoing. So there are circumstances where there will be differing findings. It depends on the powers that are also given to the investigators and what they're able to assess. And it also very much depends on the terms of reference and the mandate that's given to the investigators and the documentation that is provided to them. We've seen a lot of reports that are out there, and the there are limitations that are recorded specifically by the investigators, indicating that they were only provided with the following documentation in order to do their investigation. So I think there will be circumstances where different investigators might come to different conclusions based on the evidence that's before them and the powers that they're granted to be able to access certain of that information and documentation. Yeah, just a reminder as well. Ultimately, the Section 106 that is 106 report that ultimately is concluded and provided to the municipality. It is for the municipality ultimately to take action following on those 106 reports that are provided. So, the minister's powers end once he's sort of provided that report to the municipality, and it's for the municipal council to take appropriate action following on those reports. The provincial minister must then assess whether or not the municipality is complying with its obligations in terms of ensuring due process is followed and disciplinary processes are followed where those are required, and that it's complying with its own statutory obligations in terms of determining whether or not there's a need for provincial intervention under 139 of the Constitution. But that's a process that's not really involved in and catered for under this amendment bill and this act itself. Yeah, so I think that's
Thanks.
I hope I've answered the question sufficiently.
Yes, no, I think you have. Colleagues, I also don't want to get into a whole discussion around things that aren't relevant to the inputs from George and Mossel Bay Municipality. We did have ample opportunity in previous meetings, including the one last week, to interrogate all of these questions and queries. But if there are any other points of clarity regarding the Mossel Bay and George inputs, I see Member Masipa.
Apologies, Chair. I don't think I have put my hand up, but since I've got the floor, let me ask. Chair, obviously we have received all the inputs, and our next stage is going to be re-looking at the sum of the inputs in terms of addition or subtraction or amendment on the particular bill. Am I correct? Is the way forward?
On the next agenda item, which is item 5, we are going to go through all of the proposed amendments on a line-by-line basis and say whether we support them or not. And then after that, that is the conclusion of our involvement apart from the plenary process. Yes. Okay. Colleagues, are there any other inputs in terms of the George and Mossel Bay inputs? I don't see any other further hands. So we are then going to move on to item 5, which is the consideration of the Western Cape Monitoring and Supporting Municipalities Amendment Bill. In terms of an overview for members and those tuning in from the public, so I'll get everybody else. Our bill was published in the Provincial Gazette in 9007 on the 22nd of November 2024. Closing date for comments was the 17th of January 2025. Due to the national elections and the rising of the 6th Parliament, the bill lapsed. The bill was revived and referred to the committee in the 7th Parliament on the 12th of November 2025, ATC 42-2024. The committee was briefed on the 11th of February 2025. The initial resolution was to conduct virtual public hearings in the various regions, but due to the Independent Municipal Demarcation Authority Bill, which required public hearings, the committee resolved on the 31st of March 2025 to conduct 3 in-person public hearings on both bills. Public hearings were held in George on the 23rd of April 2025, Vredendal on the 29th of April 2025, and Cape Town on the 30th of April 2025. The Cape Town hearing was also a hybrid hearing. Advertisements for comments were placed in the Burger, Cape Argus, City Vision, Ons Contrae, and the George Herald. All oral and written comments were captured on a matrix, which was provided to the department for their comments. The matrix was distributed to the committee. The department briefed the committee on the 12th of August 2025 on the comments received and their response to it. The committee deliberated on the inputs and agreed on the amendments to be included for formal consideration. If there aren't any other questions of clarity in terms of the process that anybody would like to raise, we'll move on to the next part of this agenda. And that is the formal stage. In terms of this, we will move to the formal consideration of the bill. And I will then put the motion of desirability to the committee, after which members of the committee will be able to say whether or not they support, do not support, or will be abstaining from voting in terms of the motion of desirability. After that, we will then go through each of the proposed clauses for amendments, and members will then also have an opportunity at each stage to say yes, no, or to indicate their abstention. To save us all from being screamed through the ears with people's microphones on of ayes and noes, I am going to do that process through a show of hands for yes, no, and abstentions. Is the committee all right with that? Anybody have any objections to that? Otherwise, we just get a lot of screaming through the microphones. Okay, no objections to that process. Great. Then, colleagues, we will move on to the motion of desirability, which I will now read, after which we will then put that to the members. In the opinion of the committee, legislation is desirable to provide for certain definitions. The provincial minister to require any municipality or category of municipality by notice in the Provincial Gazette to submit information to a specific provincial organ of state, access to records of a municipality during an assessment or an investigation by certain provincial functionaries, the designation of support officers to municipalities, the designation of a provincial support officer, the amendment of provisions that provide for cooperation between a municipality and the department, procedures for the proactive monitoring of municipalities, procedures for the inspection, securing and copying of records in specified circumstances, the provincial minister to direct a municipal council to conduct a preliminary assessment on receipt of certain allocations, to authorize the provincial minister to await the outcome of investigations by other organs of state prior to taking action under Section 106 of the Municipal Systems Act or this Act, the amendment of requirements relating to the assessment to be made by the provincial minister before invoking Section 106(1) of the Municipal Systems Act, the amendment of procedures when invoking that section, remuneration and allowances payable to specified functionaries, matters on which the provincial minister may make regulations to introduce further offences, and for incidental matters therewith, and that the bill referred to the committee be taken as a basis. I put the motion of desirability in terms of the Western Cape Monitoring and Supporting Municipalities Amendment Bill to the committee, and I will ask those in favour, the ayes, to please raise your hands. Right, we have 4 ayes, 5 ayes. There we are. Those opposed, so just can everyone lower your hands quickly. Can we just take everyone opportunity to lower your hands? All right, those opposed, please raise your hands. We have 2 opposed. And any abstentions? Lower your hands. Member Stoffel, Member Constable. And no abstentions. All right, that is noted, so the ayes have it. If we can then move on to clause 1 and 2. Since no amendments have been put to clauses 1 and 2, I put clauses 1 and 2. Are there any objections? Nothing has changed. In terms of that, can I put them as they stand? Ayes, please raise your hands. Oh, just keep your hands up until you've exhausted the opportunity. So those to take the first clause as it stands. Okay, we have 4 ayes in terms of that. You can lower your hands, please. Those opposed, raise your hands. 2. All right, you can lower your hands. Thank you. And abstentions. Sorry, Member Constable, you just lower your hand.
Chair, can I ask a question before I lower my hand?
No, we can't ask questions. We're in the voting phase. You can ask a question afterwards if possible. Sorry.
I just want you to flight because I want to read what's on the specific section.
All right. Mr. Kutsia, is it possible for us to do that? I know this has been distributed, but would you be able to flight it?
Chairperson, yes. What specifically does Member Constable?
I just want to complete the voting because we have started it, and then for the next clause we'll see if we can flight it. Were there any abstentions? No. Okay. So we had 4 ayes, so the ayes have it in terms of that one. If we can then give Mr. Kutsia an opportunity, if possible, to flight those clauses. Is that possible, Mr. Kutsia?
Yeah, I'll raise a question. Member Marais did not indicate a or nay.
Yes, I did notice that. Yeah.
Do I minute him as then an abstention? Then I just need him to indicate whether they abstain or.
Yeah, if one doesn't vote, then it's just did not vote.
Okay, Chair, let me quickly, I'll bring that up.
Okay.
Hi, Mr. Chair. I'm sorry to interfere. I was busy reading and I did not raise my hand. That was the reason, but you can register it as abstention.
Thank you, Chair.
That's fantastic.
Thank you.
Thank you very much. Okay, Mr. Kutsia, should I give you a minute?
Just a minute, Chair.
All right, colleagues, we'll just take 1 minute to get that flighted.
Just looking where my bill is now. Oh. Chair, I should get him now. that visible to you?
Yeah, that is visible. So we are at clause 4 to 11 in terms of those amendments.
It's, if I share the document now, it makes me a bit difficult for me to follow the clauses as you put it.
Yes, no, sure. That's why
for
we
minute purposes, it's a little bit difficult.
Members. Yeah.
But the bills,
I see Ms. Tor's got a sorry. Yeah, sorry. I see Ms. Tor's got a hand up. Perhaps she has input or maybe a more accessible document.
Chair, just a question on clarity on the process. Will you be dealing with our proposed amendments in the able as we get to the clauses, or just as to how that will be dealt with, what we put to the committee, the department put to the committee? Thanks. The first amendment was in clause 3, proposed amendment.
Yes, yeah. So, I mean, I had got to 1 second. We had done clause 1 and 2. I'd done the first part of clause 3, and then we had to do the clause 3 as amended, which was the second part of that discussion, but we were then asked to flight that item halfway through. So I'm just waiting for it to be flighted. So we have to first put the amendments to clause 3 with any objections, and then put it as amended after that. Mr. Kutsia, in terms of those amendments, I mean, those are all included in terms of the inputs from the meeting last week, as far as I understand.
That's correct, and were distributed to the members.
Yes.
So as you put the amendments,
yes,
then they would have an opportunity to look at on their documents, and then you put the clause as amended.
Yes, as I thought. Okay. So, right. Mr. Ford, does that clarify for you?
Yes, Chair. As long as it's clear that the proposal is on a separate document to the actual amendment bill before the committee, in the able, as detailed in the able, where they specifically specify the amendments.
That's correct, Chair. Yes.
Okay. Thank you.
Yeah. Okay. All right. So we've got this up now. Member Constable, I think it's going to be tricky for us to do this very detailed now. I mean, we do have the documentation. It has all been distributed. We have an opportunity to go through it. It is now flighted on the screen, so we're going to do our best to get to those as we go through them as well. Member Stoffel, you've got a question there?
No, Chair. No. That's a legacy. Sorry,
wonderful. Chair. No problem. Okay. All right. Okay. So we're going to carry on then. So I have, as mentioned, put clause 3, the amendments in terms of any objections, that has passed. And now I put clause 3 as amended. Do we have any objections to clause 3 as amended? Sorry, Mr. Kutsia.
Just when you put the amendments, we also need to show of hands where
yes,
the
no,
members...
I'm gonna do that. Don't worry.
Okay.
Okay. All right. Okay. So can we get the ayes? Please raise your hand if you are in support. Sorry, Mr. Kutsia, can you just lower your hand?
Okay.
Member Marais, Member Masipa, Van Beek, Member Wessels. So, all right. So we have 5 ayes. You can lower your hands. Opposed? Raise your hand. 2. All right, that's it. All right, can we then move to clauses 4 to 11? No amendments have been put to clauses 4 to 11. I'm going to put that then as is. Do we have any objections? Let's take the ayes first. Please raise your hand if you are in support. Okay, there we go. We have 4 in support. Lower your hands, please. Opposed, raise your hands. We have 1 opposed. Is that it? 2. There we are. Okay. Lower your hands, please. And then objections. Sorry, abstentions. Any abstentions? Member Marais, thank you very much. You can lower your hand. Okay, if we then move on to clause 12, I put the amendment to clause 12. Do we have any objections to the amendment to clause 12? Let's take the ayes first. If you can please raise your hands if you are in support. All right, that's 4 ayes. Lower your hands. Right, opposed, raise your hands. 2. All right, please lower your hands. Abstentions, raise your hand. No abstentions. All right, so the ayes have it on that one as well. Then I put clause 12 as amended to the committee. If you can please raise your hands in support, if you are in support. Right, we have 4 in support. Lower your hands. Member Masipa, just lower your hand. All right, opposed? 2, thank you very much. Lower your hands. And Member Marais also opposed. All right, so we have 3 opposed and we have 4 in favour, so the ayes have it. Lower your hands. All right, clause 13. We have 3 more clauses to go, colleagues. Clause 13. Put the amendments to clause 13. Do we have any objections to the amendments to clause 13? Those in support, please raise your hands. Okay, we have 4. You can lower your hands. Those opposed, raise your hands. 2. All right. Lower your hands, please. Sorry, member, is that in anticipation of abstention? Are you abstaining?
Yes, that's correct. Yes.
Abstention. That's an abstention. That is noted. All right. Thanks very much. So the ayes have it. I then put clause 13 as amended. If we can then have those in support, please raise your hands. That's 4. You can lower your hands. Okay, wait, members still full. Lower your hands, colleagues. Okay, those opposed, raise your hands. Okay, members still full. Constable, it's 2. All right, so there were 4 in favour, 2 opposed. You can lower your hands. And then in abstention, Member Marais, thank you. That's 1 abstention in terms of clause 13. Clause 14, I put the amendment to clause 14. We can just have a show of hands in support. Four in support. You can lower your hands. Opposed? Wait. Opposed, please raise your hands. It's 2. And You lower your hands. Abstentions? One abstention, Member Maria. Thank you. So the ayes have it on that one. And then if we can take clause 14, and I put clause 14 as amended, please raise your hands if in support. It's 4 in support. Lower your hands. Member Masipa, just lower your hand. Opposed? 2. Thank you very much. You can lower your hands. And abstentions? Oops. Member Maria, thank you very much. 1 abstention. So that is in terms of clause 14. We then move to clause 15. Put the amendments to clause 15. Please raise your hands if in support. Thank you very much. And lower your hands. Those opposed? 2. Thank you. You can lower your hands. And abstentions? 1 abstention. Thank you. Nice to have it there. And then I put clause 15 as amended. Do we have any objections to clause 15 as amended? Can we first have those in support? Please raise your hands. Thank you. Lower your hands. Those opposed to clause 15 as amended? 2. Thank you. You can lower your hands. And anyone abstaining? One abstention. Thank you very much. All right, colleagues, I now am going to put the long title of the amendment bill to the committee. Do we have any objections to the amendment to the long title? Please raise your hands if you are in support of the amendment to the long title. Sorry, I see Member Maria's hand is still up. Oh, there we go. Those no problem. Those in support of the amendment to the long title, please raise your hands. It's 4 in support. Thank you. You can lower your hands.
Mr. Chair?
Yes.
I'm sorry, I raised my hand in support of the long title, that particular section.
Did you? Sorry, I didn't note
Yes.
that. Okay, sorry, my apologies. So that was 5 then in support of the long title. If we can then, sorry, Member Vessels, lower your hand. So we note that that was 5. Those opposed to the long title amendment? Member Stoffel and Member Possible, that's 2. Thank you very much. I then put the long title as amended. Do we have any objections to the long title as amended? Firstly, those in support of the long title as amended, please raise your hands. That's 5 in support. Thank you very much. Lower your hands. And those opposed to the long title as amended? We have 2. Thank you very much, colleagues. You can lower your hands. Right, colleagues, then the last 2 items I'm going to put to you. The first is I put the bill in its entirety as amended and I then will give the colleagues the opportunity to say whether they support or not. Do we have support for the bill in its entirety as amended? Please raise your hands. We have 4 in support of the bill in its entirety as amended. Thank you very much. Those opposed to the bill as amended, please raise your hands. That is 3 opposed. So, colleagues, the ayes have it in terms of that. I will then submit a draft report prepared by our procedure officer and myself, and we'll sign the final version of that report. And I am going to read out, in terms of the committee report, that the Standing Committee on Local Government, Environmental Affairs and Development Planning, the Western Cape Monitoring Support of Municipalities Amendment Bill, dated 19th of August 2025. Standing Committee on Local Government, Environmental Affairs and Development Planning, having considered the subject of the Western Cape Monitoring and Support of Municipalities Amendment Bill, B8-2023, referred to it in accordance with Standing Rule 173, reports the bill with amendments B8A-2025 and B8B-2025. Thank you very much, colleagues, to everybody for participating in that process, and we will then debate this bill in the House at a later stage. We then move on. Mr. Kutsia, I just want to confirm there is nothing else procedurally that we need to do. We have ticked those boxes. I see Mr. Marsdorp has his hand up. Mr. Marsdorp.
Chairperson, thank you very much for the opportunity. If you don't mind, maybe once you've done with the formal agenda, I'd like to address you and this meeting on something unrelated to the bill, if you don't mind, Chair.
Of course, Mr. Marsdorp. Thank you very much. We will do that. After this, we'll give you that opportunity before we adjourn for our resolution session. I see Member Stoffel and Member Constable. Members, you are more than welcome to raise your points. Member Stoffel.
Chair, I just want to verify with you whether I've heard you correctly. You said the committee support the bill. Is there such a sentence? I think I've heard something like that.
No, I didn't say the committee supports the bill. I said that this will now go forward in terms of the amendments. I can read the section to you again. Just give me a second. The Standing Committee on Local Government, Environmental Affairs and Development Planning, having considered the subject of the Western Cape Monitoring and Supporting Municipalities Amendment Bill, referred to it in accordance with Standing Rules 173, reports the bill with amendments. Okay. Yeah. So we have taken that to a vote, yeah, which has come through, and we voted on every one of those clauses, and all of the votes opposed have been recorded in terms of your hands that have been raised. So that process has been undertaken in accordance with our procedures. Member Constable?
Just clarity on what Member Stoffel is asking. With regards to the minority view, is this not included in the report? Because
yes.
even if we voted, the
yes.
minority view must still be included in the report.
Yes, you are entitled, obviously, you are entitled to raise that as per your rights. So would you like to submit a minority view that the PA and the ANC, as
Please.
represented on the committee, are not in support?
Please, Chair.
That's fine. That will be minuted as such, as your right. Member
And the freedom front plus.
Yes.
I think the three of us.
Yes. Yes, Mr. Chair.
Yes, that's why I'm asking Mr. Member Murray. So, Member Murray, yes, you need to confirm that?
Yes, please, Mr.
Yes,
Chair.
all right, of course. That is certainly more than acceptable, and we will ensure that that is minuted in terms of that. All right, thank you, and thank you for raising that.
Mr. Chair,
No problem. Yes, Member Murray.
I just wanted to know, in terms of our minority view, are we allowed to send in something in writing in terms to substantiate on what our minority view has been based, or is that not required?
I think that will be your opportunity to debate that in the House where that can be raised, and that would certainly be minuted in terms of that debate. But
Thank you.
I mean, if you are, yeah, great, fantastic. Mr. Marsdorp, over to you for the point that you wanted to raise.
Thank you, Chair. Thanks for the opportunity. And as I indicated, it's a point I want to raise that's not related to the bill, but certainly relevant in this particular meeting. Chairperson, I have been assigned to this committee to assist and guide the committee in respect of any legal advice or guidance it may need in processing this bill. Over the years that I have been here, which is 17 years, I've been assigned to countless committees. I've seen countless bills coming by me, and I have given innumerable advices and guidance to committees. Over the 17 years, I have given countless pieces of advice to the Speaker in person, to the Speaker's management team in person, and I have done so with the utmost of professionalism, the utmost of ethical composure, and the utmost of personal satisfaction. That's what I've been doing for 17 years. I was assigned to this committee similarly to do this and give advice and guidance to this committee in relation to this bill. 29 years ago, 1996, the 6th of September, I was admitted as an advocate of the High Court, and I'm an officer of the High Court. I was appointed here as legal advisor, and with all the ethical and professional imperatives that come with that role, I approach committees, I approach my job, my KPIs, and my responsibility emanating from my contract of employment. I am the sole curator. I am the sole protector of my professional reputation. No person, and that includes everyone in this meeting, no person, everyone outside of this meeting will willy-nilly, frivolously, brazenly cast aspersions on my professional reputation. No person, including everyone in this meeting, will cast negative, defamatory aspersions on my objectivity as a lawyer, as an advocate, as a legal advisor, as a human being, without foundation, without corroboration. I will not indulge that because I'm the sole curator of my professional pharma. It was said earlier that the legal advisor and my colleague in law, Advocate Birch, my colleague in law, Ms. Tor, can certainly speak for themselves. I hold no remit to talk on their behalf. Marsdorp is my surname. I speak for myself now and always. No person will be allowed I will indulge no person to, without foundation, cast negative aspersions on my professional farmer and on my personal name. My professional integrity is the only equity I have in this building, in this capacity as legal advisor, and I will protect it. For someone to say that because I am in the Western Cape Provincial Parliament, I am therefore not constructive. For someone to say that because I am employed as a result of, and as a result, I am not objective, without substantiation, that's a stretch too far to buy my silence. That is a stretch way too far to buy my silence. I don't take kindly to that. I do not expect anyone, and with respect to you, Chairperson, I would like to urge you, because you see, Chairperson, on a platform like this, I give only legal advice. That's the sole role for my relevance and presence here. But officials, and here I include my colleague-in-law Birch and Tor, officials are often vulnerable
Chair,
when it comes to.
Chair, can I have a point of?
Can I round off my chair?
Can I have a point of order, Chair?
Yes, you may raise a point of order. Sorry, Mr. Marsdorp.
Chair, I think you understand my question when I ask where is the MEC and where is the HOD. It is exactly this that Advocate Marsdorp is now talking about. My point of order
No, I don't.
is that
Sorry, Member Constable. I think Member Constable. I don't. Member Constable. I don't think that's what he's. I don't think that's what he's speaking
Chair, my
about.
point of order.
Carry on. Yes. Yeah.
Can I then bring my point of order?
Yes. Please bring the point of order. Yeah.
My point of order, Chair, is then that if there was any aspersion caused, Advocate Marsdorp can then put that in writing, but I don't believe this is the platform for him to talk to members of this legislature like this.
Yeah.
Then we can respond also in writing. Yeah. Thank you, Chair.
Yeah. Thank you, Member Constable. Mr. Marsdorp, I'm going to rule on this because I do recall the comment that you are referring to, and I did listen to it. There weren't names mentioned specifically, which is why I didn't respond or rule the member out of order at the time. But I do understand your point, and I do think that this is something that should be dealt with outside of this meeting. I think it's going to be difficult for us to raise this and deal with it now. But I do think that you have had an ample opportunity to respond, and I understand that you felt that that was a personal attack on yourself. But I do see Member Beauty Stoffel has her hand up. After that, I see Member Masipa, but Member Stoffel first.
Thank you, Chairperson. Chairperson, I think at some times we should be allowed to exercise our constitutional right as expected of these members of this committee. And here we are guided by the Constitution. And by mentioning the word Constitution is to remind us all that whatever we are saying here, it should be in line with the Constitution. And that's the obligation of this committee. Now, if someone felt he's been attacked based on the argument of justifying the Constitution in its right expression of way, then I don't know where we're supposed to raise our concerns. So, and I also appreciate what you have sponsored to Advocate Marsdorp in terms of his unsatisfaction about what was being said in the committee, and you can take it up with him outside or can put something on writing. I agree fully with you with that. Thank you, Chair.
Thank you, Member Stoffel. And just to confirm from your side, it wasn't a personal attack on the integrity of Mr. Marsdorp or either of the other legal advisors.
Come again?
No, I say just to confirm from your side, it wasn't a personal attack on the integrity of Mr. Marsdorp or the other legal advisors.
No, I don't know whether these comments from Mr. Marsdorp was referring to me, because in this committee we should be open about the discussion. And if he said with my statement I was offending him, I was articulating on what was on hand, what I seen. So if he take it up as a personal attack on him, I'm not going to find myself in that space.
Okay.
Thank
you. Thank you, Member Stoffel. Member Masipa, Member Maria, I'm going to take those two hands. I would like to close this item. I do think it has been sufficiently ventilated, but Member Masipa first.
Yeah, thank you, Chair. I think Honourable Constable kind of covered me, but I also just want to say that I'm completely caught off guard with the statement by Mr. Marsdorp. But also what I really will urge colleagues is that obviously, you know, we've got a platform of political debates, and I think it's imperative that when we deal with officials and parliamentary staff, that we really make sure that we understand that, you know, our political engagements will take place in the House. But here, really, as much as they try to support us, let's support them to make sure that we do our job, you know, eloquently. Thank you, Chair.
Thank you, Member Masipa. That is noted. And Member Murray.
Thank you, Mr. Chairperson. Just a comment. Mr. Chairperson, I think it's important that we understand that we have departments and then we have a legal professional that's appointed in Parliament to advise Parliament. And I was a bit concerned about the comment by the honourable member casting aspersions. I picked it up as a member of this committee, and I do think that I just want to caution us to appreciate the legal team that works in Parliament is objective. I have seen it. I appreciate that professional edge to this committee, but I also just want us to, I think, just allow Advocate Marsdorp to have his say in the matter, because it affected his person and also his function in this Parliament. And I think that we should never doubt the objectivity of our legal team, especially Mr. Marsdorp or Advocate Marsdorp, who I've known for a few years, and I've also listened to him in terms of legislation that he has commented on. So I don't want to say any more than that, except to say that he has a right to respond if any comment has been made that affects his person and also the work that he does for Parliament. I have no doubt in the objectivity and the professional way in which he has provided inputs to guide this committee. And I think going forward, we should appreciate his role in our various committees, and his objectivity is unquestionable. Thank you.
Thank you, Member Murray. Colleagues, we have received confirmation from Ms. Stoffel that it wasn't intended as any form of personal attack on the integrity of our three officials who were mentioned. So I'm going to take that as per what has been already confirmed by Ms. Stoffel, that was not the intention. But that said, I would like to give Mr. Marsdorp the opportunity to write to the committee, just detailing some of his concerns so that we can address those as best possible going forward. I'm not going to allow us to continue to discuss this matter now. We do need to get on to the last item of our agenda in terms of the resolutions. So Member Stoffel, Member Constable, I do see your hands raised, but I'm going to close this item now. We have dealt with it sufficiently, and we're going to move on to the final item, which is the resolutions. So in terms of that, members, please stay behind.
Chair,
Yes, Member Constable, is it a point of order?
Chair, please don't do that. Member Marais put something on the table, and I need to clarify, because I always, in my debate or what I'm putting in front, because there's a legal team, I always mention the names of the legal team. We don't, or let me say, me as a member, never question their profession. They are legal team, they are highly qualified, and we respect them. That's why it is for me very disturbing to put them in a position, because they obviously only doing their job. But to think that we are questioning their credibility, that's very wrong. We never question their credibility. We ask them to put them our needs also as part of what they're doing. I even urge them to come and do practical assessments on this thing. So from my side, Advocate Marsdorp and all the legal advisors of MEC Bradell, please, we never questioned your credibility. We never questioned your profession. This is a political bill, and we debate it as political people or members in the standing committee. Thank you, Chair. Thank you for allowing me to speak on this also.
Thank you, Member Constable. So I think we have then overwhelming support for the notion that we have complete trust in the integrity of yourself, Mr. Marsdorp, and the officials, and apologies for any offence caused by comments that may have been misconstrued in terms of that. And as mentioned, you're more than welcome to write to me, and I will take up any concerns you have to the best of my ability. Thank you. The officials who are present are now welcome to leave. I'll give you 30 seconds to log off, and then we will move on to the last item, which is just briefly in terms of the resolutions. 30 seconds. Thanks very much, colleagues, and thank you to everybody for handling that in a professional manner. I think it shows a lot of maturity from everybody in the team, and thank you very much. It has been a tricky meeting to try and get together on a virtual basis, but I think we all managed to get our points across and put the positions of our various parties and caucuses forward as well. Colleagues, the first item I want to put to you is just the one set of outstanding minutes from the 12th of August. Can I have a proposer and a seconder for those minutes? Member Masipa and Member Wessels, thank you very much. And Member van Wyk, I apologize again for referring to you as Member Wessels. I don't think I had my strong enough coffee this morning, but thanks very much. And I hope you've enjoyed your first meeting. Would you like to say hello to the committee?
Yeah, no, hi there, committee members. Yeah, obviously it was a little bit of a different start in being in the middle of a bill such as this, but look, we know each other around the table there, so great to be with you guys. So look forward to ongoing meetings. Thanks.
Thank you.
Welcome.
Thanks. You're coming straight into some public hearings as well, which are going to be starting next month. So we're going to have 4 public hearings, so we'll get a chance to spend some more time together as well. And then finally, colleagues, are there any other resolutions? I know everything has kind of been captured in terms of our inputs with regards to the bills. And our next phase of engagements is going to be on the land use planning amendment bill, and that will be those things that we're embarking on. Are there any other resolutions or inputs that anybody would like to make? Member Stoffel. Member
Yes,
Stoffel.
Chair. Sorry, Chair. Yes, Chair, mine is not a resolution. Mine is about what have happened now. I think I have to give a comment on that. Chair, we also need really, you try to protect us. You tried. But we also need really protection from these educated people. We've been placed here in this committee to do our utmost best to see that in anything that we are debating here, our people's right is not being dismantled or being violated. Let me put it like that. And we have been mandated by our political parties to come and discuss. As Member Constable have indicated, this is a political portfolio itself in its nature. So at some stage, we will touch on political issues. And by doing that, it's not trying to offend those people, because those people have classified us now as uneducated people. As much as he say he's been, how can I say now? We have, what is this word? He also offended us by classifying us as uneducated people. That's how I sum it up. Just because of our view. Now, Chair, I don't want to take the discussion further. It's just I have to mention that. At some stage, we must also be protected. And you have done so by indicating whatever have coming out here was never to offend anyone. It was led by the debate. So, Chair, thank you very much.
Thank you, Member Stoffel, for that input. I appreciate that. And I think, yes, I think it's just, yeah, as I mentioned, I did listen very carefully. I don't want to get into the details and thrash this out now. I mean, we are still on a public forum, but I think if there had been a comment directed at an official in particular casting aspersions, that certainly would have been ruled out of order, because, you know, we also do need to protect the integrity of our officials, but I think it was dealt with well. Colleagues, any further comments on this? And if there are no other resolutions, Member Constable.
Chair, just 2 possible resolutions from my side. I think MEC Bradell in last week's sitting said that we must maybe again in detail talk with regards to the I think it was the landfill sites, environmental affairs issues. What is it? The transfer stations. Look in depth in that. So I think this is what we can put on the resolutions. The other one, Chair, the question that you also raised with regards to the municipalities that have unfunded budgets. You specifically ask how many in this province. Can we ask for a total report with regards to the support that was given to that specific municipalities from local government? Thank you, Chair. And maybe from local government. Thank you, Chair.
Sure. I know in terms of that oral response, because they also sent out the written versions of those oral responses, and there's quite a lot set out in there. So have a look at that in the meantime, but we can certainly ask that that be expanded on, so we can get more detail on that. Thank you.
Thank you, Chair.
Member Masipa. Member Masipa, are you wanting to speak? You lowered your hand. Member Wessels?
Oh, sorry.
Oh, are you?
Sorry, I thought I was unmuted. Apologies, Chair. So mine is not a resolution, but just to what Honorable Stoffel has just mentioned. I just thought I must just say this. You know, we are a multi-party, committee where we really represent, the citizens of the Western Cape in this committee. Sometimes bill might not go my way. But I think we are also welcome to provide a minority report, and even in the debate in the House, it provides us with that opportunity if it's not really to our liking. So I thought I will just mention that, for colleagues, to just make sure that, your constituency is well represented, with bills like this one. Yeah, I just thought I should make that point, Chair. Thank you.
Thank you, Member Masipa. Member Wessels?
Thank you, Chair. Yeah, maybe as a resolution, and this bill, and even to what Member Constable spoke to earlier with regards to his resolutions, would it be possible to request a report on the status of municipal managers within the Western Cape? So by that, I'm asking how many are under certain waivers, or how many positions, municipal manager positions, are vacant. All of that type of detail. I'm not exactly sure how to phrase it, but the status of municipal managers per town or per city in the Western Cape. I think that would, that's the head of administration in a municipality, and leads to budget stabilities within these local.
Okay.
Yeah.
Thanks. Member Wessels, can I ask you, if possible, we'll capture that, but if you can maybe just write a little bit, just a couple of lines, just specifying, because I think this is important to make sure that if we are going to get that presentation, that we get, everything we can out of it. So if you can just detail a little bit more exactly what it is you want in line with some of the things you mentioned now, just so that we get the quality. That's great. If you can send that through to myself and Mr. Kutsia, but we'll certainly capture that in the interim. Member Constable?
Perfect.
Thanks, Chair. Chair, with the permission of Member Wessels, can we not broaden the scope? Because I believe the heads of the administration, the MM and all the directors, if we can maybe specifically with regards to your corporate services component, as well as your chief financial officer component, because that is for me the crucial part of a municipality. If you can maybe add that also. Thanks, Chair.
Yep, Member Wessels given a thumbs up, so that's great. We can certainly add that. Member Stoffel?
Thanks, Chair. Chair, I think they are correct. They are correct in terms of that resolution. But I think we should then maybe consider the issue of expanding it more to say there should be a representation on the establishment of each and every municipality when it comes to appointments, because what we have noted, even here locally, there's still a lot of vacancies within municipalities that is not being filled. Most of the municipalities sitting with bloated establishments. You still got ghost workers within your municipality that is somewhere but is getting a salary. So I think we should really go deeper into this report so that we can get to the bottom of a lot of other issues emanating out of that. I think we should make the scope broader to say in order to address what Member Vessels and Member Constable is proposing.
Okay, thanks. Thanks, Member Stoffel. Yeah, and we can also obviously interrogate, you know, if we have that presentation to ask more of those questions as well during that meeting. So certainly, yeah. All right, colleagues, I don't see any further hands. I just want to thank you very much for the meeting and for helping to get through it, and for your professionalism all round. And wish you the best of luck for the rest of your Tuesday and the week. And I'll see some of you later on in Member Masipa's meeting. Thank you very much. Have a good week. Meeting is adjourned.
Thank you. Thank you, Chair.
Thank you, Chairperson.
Thank you, Chair.
Thank you, colleagues.
Chair. Thank you.
Bye.